Your name, sir?
Kiwan Atkins Richards.
I'm sorry, Your Honor, I was listening for Kiwan. I didn't realize that was him. If you're Richard McDuffie for the people.
All right,
We'd ask the court to set this for examination.
discovery is complete.
Your Honor, I have a request from counsel for the 911 call. I believe that will be here by some point next week. I just want to confirm, since Mr. Ashton Bridges is a co-defendant along with Mr. Correll Brown, who's represented by Mr. Kilroy, that counsel is seeking to hold separate exams in that whole exam.
Separate exam.
When is that other one set?
Mr. Brown is over his first CCC, probably right after this break from today's docket.
We'd like the earliest date possible.
Judge, just for the record, Robert Kilwell, I was just appointed, but I met with Mr. Brown last night and he wants to proceed to exam.
All right,
Just for your info.
very good. Preliminary examination in this matter will be set July 29th, 2025, 9 a.m. That is before Judge Barr.
Thank you.
Bond will continue.
Thank you.
Case People versus Bianca Rowell.
Morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor, again appearing on behalf of the people.
Kyle Burrell on behalf of Ms. Rowell. Bianca, please state your name for the court.
Bianca Rao.
Your Honor, Anali is en route to your staff.
All right.
And so I don't think that we need to worry about this matter much further.
Okay.
Before it could get to you, unfortunately, I'm sorry.
That's fine.
Okay.
Any objection to the dismissal?
What do you think, Bianca?
No.
No, Judge. No objection on this one.
Case is dismissed. I'll sign off on that when we. Court does call the case People versus Correll Brown. This is the co-defendant.
Yes.
Hey, did I get 29 bar?
Good morning, I'm Rob J. Kill on behalf of Mr. Correll Brown. Correll, would you state your name?
Correll Brown.
Judge, I would, like I said, I was just appointed, but again, we met last night for a significant period of time. I do have the discovery. He's seeking a preliminary exam in this matter.
All right. Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Barr.
Thanks,
And
Judge.
Your Honor, just confirming again for this record, since Mr. Brown requested a separate exam, that these are on the same.
I'm gonna let Judge Barr decide whether or not the exams are held jointly or separate.
Okay.
I put them both before him. He can make that decision. Thank you.
Thanks.
Court calls case People versus Taylor Adams.
Assistant Public Defender Jay Bellinger on behalf of Mr. Adams, who approaches. Mr. Adams, can you please state your name for the record?
Taylor Adams.
Thank you.
Your Honor, I am just requesting a 3-week adjournment for purposes of completing mitigation and having that reviewed by Ms. Londy.
Without objection, August 7th, 2025, 9 a.m. bond continued.
Thank you, Your Honor. I will be giving you a copy. Thank you, Your Honor.
Court calls case People versus Kimani Hamilton.
Good morning, Rob J. Kill on behalf of Mr. Hamilton. Judge, would you state your name for the record?
Kimani him.
Judge, I met with him last night. There's a lot of issues that we have to discuss. I'm asking for a brief adjournment.
Probable cause conference will be adjourned to July 31st, 2025, 9 a.m.
Let me see.
Bond continued.
Thank you, Your Honor.
Court calls case People versus Abdul Rahman Al Datif.
Testimony for the people.
This is the court defender on behalf of Mr. Al-Daishi, who's now approaching. Please state your name for the record.
Rahman Al-Dai. Anti-pockets.
Go ahead. What are we doing?
At this time, Your Honor, we'll be setting this matter for a preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available on the 29th.
We'll try, Your Honor.
Preliminary examination in person, July 29th, 2025, 9 a.m. That is before Judge
Washington.
Judge Washington.
Thank you, Your Honor.
Thank you. Bond continued.
I'd like to class of hearing on behalf of the ministers.
Pardon?
State your name for the record.
Lamar Bradford. Thank you.
Your Honor, at this time, we would like to waive over to circuit court.
Sir, is that correct?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would
Here comes another adjournment. Super common in real courts. These delays aren't stalling, they're strategic. Lawyers use them to gather evidence, negotiate deals, or buy time to fix chaotic case files.
have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on all three counts. Your turn.
We acknowledge the information and receipt of the information, and we waive its reading, and the client stands mute.
Defendant having waived for more reading, standing mute, court will enter a not guilty plea. As to all counts, pretrial will be set for
July 30th at 1:30 with Judge Conlon.
July 30th, 2025, 1:30, Judge Conlon. Court does call the case of the people versus Amar Amadou. Ms. Cannon,
Oh, I've got it, sorry.
so I don't get to yell at her, I get to yell at you.
No, I'm sorry, she just kind of handed them off to me, Your Honor, and left. So, I'm sorry, what was the name, Your Honor?
I'm with you.
Yes, thank you, Your Honor. Student Attorney Kara Rosingen requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Hannah Apple on behalf of Mr. Amado.
Permission to practice is granted.
Thank you, Your Honor.
Where's your client?
I'm sure I don't have any idea. I'm sorry, you'd have to ask Miss Cannon. You'd have to ask Miss Cannon.
I'm going to reiterate, I'm sure I have no idea.
But we are asking for an adjournment in this case, Your Honor. We're requesting a 2-week adjournment.
You can hand me that, it's not gonna happen. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Court does call the case of the people versus Troy Brumfield.
Assistant Public Defender Hannah Apple here on behalf of Mr. Brumfield, who's approaching now. Mr. Brumfield, will you state your name for the record?
Troy Brumfield.
Thank you.
Your Honor, Mr. Brumfield wishes to waive his preliminary exam today.
All right. Is that correct, sir?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Thank you. Your Honor, defense would acknowledge receipt of the information, waive reading, and my client would stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 28th at 1:30 with Judge Simpson.
July 28, 2025, 1:30, Judge Hamud. Bond will continue.
Thank you.
Just sign off. Court does call the case, people versus Dominic Billing.
Student Attorney Kara Rosengren on behalf of Mr. Billings. Could you say your name for the court?
Dominic Billing.
All right.
Your Honor, Mr. Billings is going to waive his right to preliminary exam today.
All right. Sir, is that a correct statement?
That is.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes,
I understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Mr. Billing waives formal reading and stands mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 8th at 1:30 with Judge Simpson.
September 8th, 2025, 1:30, Judge Hamud.
Thank you, Your Honor.
Bond will continue. They're gonna need that. I didn't pull it out. Court does call the case of the people versus Robin Finney.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Ms. Finney, who's approaching. Ms. Finney, can you state your name for the court?
Yes, Robin Lee Finney.
Thank you.
Thank you.
And Your Honor, I apologize. I do have a green sheet. I am requesting an adjournment, a 2-week adjournment in this matter for continued discussion with the APA.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case of the people versus April Black.
Stephanie Cannon on behalf of the board. April Black.
This bond modification request is intense. The defense argues emotional trauma. The prosecution argues public safety risk. Classic courtroom tug-of-war. But pay attention to how the judge responds. Judges almost always side with safety when emotions and danger overlap.
Thank you.
And Your Honor, in this case, we are asking for a brief adjournment for mitigation purposes. My client has provided me some information. I need to provide that to the prosecutor's office.
Probable cause conference, August 7th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. August 2nd. Oh, you want to address the cover? Your Honor, may I address bond? I'm so sorry. May I address?
He's out.
What?
Go ahead.
Oh, I didn't hear what you said, Your Honor. I'm so sorry. Your
I'm
Honor.
happy to change it.
Oh, he's out.
Go.
You're not going to change it?
No, I don't know what you're asking.
Oh, so Your Honor, my client is currently on tether. We're asking that the tether be removed. I have reviewed her file and the information in this case. She is charged with malicious destruction of property and resisting an officer. The police report itself is replete with information that has nothing to do with her resisting charge. It's my understanding, since then, she's been very cooperative with the police regarding the situation that pulled the police to the scene, which was a shooting. My client wasn't a part of the shooting. She was a victim of the shooting. Her and her mother has allegedly done some behaviors where she destroys a little bit of property, maybe they'll say, and she's going to pay for that. She understands that she has to pay for that, and she did resist. However, my client in that time frame was exceptionally emotionally distraught from the shooting. Her whole thing was to get away from the scene, to leave. And yet somehow, some way, my client, and again, she's done lineups, she's done everything the police have requested of her regarding that shooting. She has no other criminal history. She's not a threat to the public. She's come to every court appearance, and she will continue to come to every court appearance. We're asking that the GPS tether be removed, Your Honor. In addition, it won't allow her to go see her mom when her and her mom were trying to get away from the situation. And so she's also confused as to why the court is keeping her from interacting with her mom when her and her mom were victims trying to get away from the scene.
Response.
Yes, Your Honor, I did your payment on this, so that perhaps gives me a little bit more insight. So what happened here is, in my understanding, is there was not actually a shooting, it was an FA of Ms. Black's mother. And the reason that she has that tether is that Ms. Black is accused of repeatedly trying to go to the home of the people she believed did that, which is just a few doors down from her mother. So there's no order that prevents contact with her mother. The order prevents contact with her mother because at the time this happened, Ms. Black was visiting her mother. And when the police responded, they actually used a lot of restraint with Ms. Black as far as they tried to just get her to calm down because they understood she was upset. She repeatedly told the police that she was going to the residence where the suspects were. And they kept telling her, no, you're not. And she kept telling them, yes, I am, and kept trying to walk over there. They had to physically stop her multiple times. Eventually, they ended up having her sit in the car, try to give her some time to calm down. When they let her leave from the car, she again said she was going there. And so, Your Honor, it was because she refused to calm down as far as going to that location, that there was that concern for safety. So there's no attempt to stop her from seeing her mother. It's to keep her from going to that other location that's just a few houses down.
Your Honor, and I'm sorry, I'm sorry, because she just finished. I'm so sorry. Please continue.
So that's why she had the tether. There could not be a hot zone because Ms. Black lives so close to the location, and so to resolve that issue, it was a tether with a no-go instead of a tether with a hot zone. So that's why there's that.
Gotcha. And I don't see an order prohibiting contact with her mother, so I don't know where that.
So she goes there, she takes her children there. This is somewhere that she used to go every single day because she takes her mother there. Now, we understand that she's not been charged for the felonious assault of anyone. She didn't go to those people's houses. She's not trying to go to those people's houses. She's calmed down a great
Oh, but the
deal.
allegation is that she tried to go there on that night, that she tried to go toward where these people were that committed the other alleged act.
Yes, Your Honor. So that is the situation, but my client doesn't want to go there. She's calmed down. She's never been there before. She has no intention of going to these people's house. It was just an emotional situation at that time. She's not that person, Your Honor. And she's asking for the court to give her the opportunity to show that that was a momentary lapse of judgment that she will not go back to.
Motion to modify bond is denied. Bond will continue. The GPS will continue.
Thank you, Your Honor.
Carolyn Foster Tucker on behalf of Antoine Brown.
Your name, sir?
Antoine Brown.
Thank you.
And Your Honor, we are requesting a preliminary exam in this matter,
All right. All discovery is complete.
to my knowledge.
People have their witnesses available the 29th.
Yes, Your Honor, and I do believe as far as discovery, we did request the 911 call earlier this week, so it should be here prior to exam.
Okay.
Okay. Preliminary examination in person will be set July 29th, 2025, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Oh, you're on your work. Court calls the case, People versus Ibrahim Siddiqui.
Alexander on behalf of the people, Your Honor.
Assistant Public Defender Nicholas Bukovich, on behalf of Mr. Diakite in matters that end in 1232 and 1233.
Morning, I'm Rob J. Kilwall. Judge, I'm on 5153.
Okay, what are we doing? Sir, Mr. Dick, he's still muted.
Yeah.
Did you? Why is he brought up?
Oh, there he is. Sir, can you state your name, please?
Ibrahim Jakaite.
Okay. What are we doing?
In the matters that I represent, Mr. Diakite on 1232 and 1233, we will be requesting a set for a preliminary exam. To my knowledge, all discovery is complete in both of those cases.
Same with 5153.
You want an exam set?
Yes, Your Honor. I did meet with him last night.
So keep an eye on.
People have their witnesses available the 29th.
We'll do our best, Your Honor.
Preliminary examination will be set in person July 29th, 2025, 9 a.m. before Judge Washington.
And Your Honor, when appropriate, my client would like me to address bond.
Go ahead.
Yes, Your Honor. Mr. Diakite would like me to request a release on tether. He does not reside at the same location as the complaining witness in the 1232 case. Prior to incarceration, he began working full-time as a caregiver. He'd like to be able to return to that work. He does not have to be, he has no reason to be in contact with the alleged complaining witness in this case. No children in common, no residents in common. He does have his own transportation. It will be able to return to court. He does have ties to the state of Michigan as he has family who resides within the state in different cities. So he'll be requesting a tether with a release on tether, personal reconnaissance bond for release on tether in his cases.
Your Honor, just two things on my case. I'm trying to figure out what the bond is. Does your record show what the bond is on the 23 case?
The 23 case bond is 1,010%.
All right, thank you, Judge.
Response?
Your Honor, I would object to any modification of bond.
This defendant is looking at 3 cases here, and I'll focus each, one by one in his.
This bond modification request is intense. The defense argues emotional trauma. The prosecution argues public safety risk. Classic courtroom tug of war. But pay attention to how the judge responds. Judges almost always side with safety when emotions and danger overlap.
Are in no case he is an officer tried to stop the fight and told the officer that he was going to kill him when he got out of jail. At his next case, he was throwing rocks at someone's windows. Officers arrived, saw a motorcycle leaving, confirmed it was the defendant, and a pursuit began where he reached speeds of over 100 miles per hour in a 45-mile-per-hour posted zone. He was caught after the motorcycle had stalled, and the motorcycle turned out to be stolen. And then in his third case, him and the victim who were working together, had a dating relationship. An employee at that restaurant called 911 to report that the victim had been dragged from the women's restroom, kicking and screaming, to a car, and the colleagues at work had saw visible scratches on her face. And after being put in the car, the defendant then drove away, and the victim jumped from the car, and officers found her in the middle of the roadway. I also wanted to report that he has a previous ED conviction from 2023, and he currently has a hold from Delta County with bond denied. So I would be asking that bond remain as set in this case, Your Honor.
Anything else?
No, yeah.
All right.
Nothing from me. Nothing
Given
from
all of those circumstances, motion for bond reduction is denied. Bond will continue in all 3 matters.
Thank you, Your Honor.
Thank you, Your Honor.
Appearing on behalf of Ryan Gerard. Please say your name for the record.
Ryan Gerard.
Your Honor, at this time, we are requesting to adjourn this matter for pending negotiations with the prosecutor.
Probable cause conference will be adjourned to July 31st, 2025, 9 a.m. Bond will continue in these matters.
Thank you, Your Honor.
Court does call the case of People versus Cameron Jones.
If you ever to make this for the people.
Carolyn Foster Tucker on behalf of Tamarian Jones.
Your name?
Mario Jones.
Thank you.
And Your Honor, we're just requesting a brief adjournment in this matter. I've talked to APA McDuffie, and she indicates that there's an offer that we need to discuss.
August 7th, 2025, 9 a.m. Bond continue.
Your Honor.
Thank you. The People versus Hiram Haywood.
Good morning, Victoria Burton here, Chief Assistant Prosecutor again, here on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Hiram Haywood.
Your name, sir?
Hiram Haywood. All right. Your Honor, today is the date and time set for the probable cause conference. However, we are working towards drug court resolution. We need time to be able to put in a request so that we can make sure that he can be accepted to that drug court. So we're going to ask for a 2 adjournment by the time we.
And I don't mind giving you the 2 weeks, but the timing that I was getting yesterday, I don't know that that's going to happen. To be honest with you, so I'm going to go. I certainly don't want to go so far out, but I'm going to go August 7th, just one more week out. 2 weeks. August 7th, 2025, 9 a.m. His bond will continue.
Thank you, Your Honor.
Thank you.
Pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecutor Attorney Alexander.
So you're under supervision of who? So it's the end of the day? You guys made up? Okay, well, never mind. I don't know. Something Douglas was in the middle of it all. All right. Permission to practice is granted.
Good morning, Your Honor. Roba Hamden requesting permission to practice. I'm so sorry.
Now, it's okay. You're scared? Am I doing it?
I just my mind went blank for a
You
second.
did it? Mine does that too. Go ahead. Just hold it. Do me a favor.
Requesting
Hold on.
Oh, okay.
Take a deep breath.
I'm breathing fine, Your Honor.
Apparently not.
My mind just went blank.
All right. All right. Just relax. Okay. Go ahead.
Good morning, Your Honor. Roba Hamden requesting permission to practice under MCR 8.20 under the supervision of Assistant Public Defender Jay Ballinger.
Okay, very good.
Sorry, Your Honor.
Oh, so it was it's his fault. I get it.
I don't know. I got
No,
thrown
no,
off.
it's Bellinger's fault, trust me.
Probably you don't have to apologize. So.
All right. Your name, ma'am?
Zaria Brand.
Thank you. All right, what are you doing?
Your Honor, mitigation information was sent to Prosecutor Zenda for review. The prosecutor is seeking adjournment to review.
To look at all of that over. All right.
I'm sorry?
That needs to be reviewed and an answer given.
Yes, and they also wanted to speak to the claiming witness as well.
Pardon?